464 Foundry is being continued?
Correct.
Okay. And I just suggest, I think perhaps we could put off the meeting schedule, just because, I mean, I guess the three of us could comment if any particular days are definitely not doable. That way it'll narrow it down for the next meeting.
Sure.
Mm-hmm.
Good evening, Rob.
Good evening. Is it just us three tonight?
It is.
We have a triumvirate.
Mm-hmm. All right, well, should we start up? Time?
Yes.
Okay. All right. Hello, welcome to the November 7th, 2022 regular meeting of the Planning and Zoning Board. This meeting will be held remotely according to the usual state guidelines. You have the option to attend the meeting or view it. You have the option of clicking the Zoom link on the agenda or using the call-in feature. Greg Strange, the chair, is absent, so I will be the acting chair tonight. And Amas, our alternate, will be acting as a full voter. So we'll start with a roll call. Robert Stetson here.
Here.
Amas Kadem.
Here.
Peter Duchesne here. Okay. That's all the introductory items, correct?
Yes.
So, okay.
Oh, sorry, Peter. Do you want to give instructions on how people might participate if the chair is entertaining
yes.
comments?
Yes, the Zoom application has a couple methods to comment. One being the chat function, and the other being the raise the hand function. We'll try to monitor those and review the chat or promote you as a panelist at the appropriate time. And that will be. So the first item on our agenda is the continued public hearing for 464 and 466 Foundry Street special permit and site plan endorsement. However, I believe that is being continued to the next meeting.
Motion to continue 464 and 466 Foundry Street special permit multifamily and site plan endorsement to next meeting on November 14th?
21st.
21st.
Second, Stetson.
Okay. All in favor? Kadem? Amas, are you in favor of continuing?
Yes. Yes.
Robert?
Yes.
And Duchesne, yes. Okay, next item is the follow-up on Administrative Appeal 22-10, 6 Chickadee Lane. This is an appeal before the board of the Eastern Massachusetts Zoning Board of Appeals, where one of the landowners is operating a farm, and one of the abutting landowners has appealed some of their farm operations. So we don't actually make a decision here. We just decide if we agree to that we might either recommend or not recommend to the Board of Appeals, which is the ultimate decision-making authority here. Having said that,
Yeah.
I'm not sure if anyone else thinks it's more appropriate just to focus more on the special permit common driveway components, or otherwise the floor is yours, and start it up.
So, Peter, I'd just like to remind the board this really isn't a recommend or not recommend. It's more if the board feels there are any comments they'd like to make.
Yes. So
to
I see. Oh, given that it's an
Yes.
administrative appeal, it's
Right.
a little bit
Right.
different than the usual process. Okay, so similar but different.
Just to be more clear, I think what they are appealing is the decision of the building inspector that decided that there is no violation.
That is correct.
That's the appeal that is these people are bringing. And I'm confused because all the discussion is about the covenant and the maintenance agreement of the driveway. That is that I don't know if this is under the building inspector responsibility to see as well. If it is, then the appeal is correct. The building inspector did not take in consideration that aspect of this issue, and he was looking only about adhering to the bylaws, right to farm and Dover or whatever that is.
And if I could just respond to that, Peter.
Mhm.
And thank you, Amas. I have reviewed the common driveway special permit, and there really is reference in that to the driveway being specifically granted with the condition that it only be used for residential. And I was talking with Michael Kennefic from Town Council's office, who is providing support for the Board of Appeals. And it does appear that the agreement, which would be any common driveway that is permitted by the Board of Appeals, must have an agreement that defines how the parties are going to manage the common driveway, how they're going to repair for it and provide for it, and how how they'll use it. But that's the agreement between those parties. It's not really a condition. There's a condition that such an agreement exists, but the board doesn't define or condition what that permit should look like, other than that it needs to address how the common driveway will be taken care of.
Are you saying that that issue is not in the purview of this board or even the other board or the inspector? It's not something and that's the reason it's in court and the court needs to decide.
That would seem to be the case, yes.
Do you agree?
Yeah, that's what we talked about last time. I mean, I looked over some of the papers, and we finally got the other side's position on the matters at hand, and I mean, I think their position is much like we had been talking about, with respect to Dover and right to farm, and for better or for worse. I'm not sure I disagree from a legal perspective. So I don't really think there's an awful lot that we can do. Whatever our personal feelings and opinions on the situation may be, I'm not sure there's much that we can do. And certainly I don't think, I mean, unless, Peter and Amas, you have a different view on things, I don't think there's much here for us as a board to go against what the building inspector had found here.
Yeah, but this board granted a special permit, and there were conditions to that special permit. Are those violated?
I'm not sure that they are, but I'm not sure it matters for the reasons that I talked about last couple of times we've discussed this. I mean, it's an agricultural use. We don't necessarily even have the ability under special permit to regulate it.
And that's also why one of the reasons that the zoning bylaw treats agricultural use in such a way is that we, when we revise the zoning bylaw, we consult with the land use attorney of the town council, and part of that is that they tell us what we can and can't do based on the state law, and certain parts of the zoning bylaw, we construct to conform with the state law so that it's not conflicting. And I believe that agricultural uses and other Dover items usually come into that discussion at some point, and that's part of the reason why the zoning bylaw is the way it is, and maybe perhaps to promote agricultural use in certain situations. So, but yeah, I mean, Robert, I agree with you. It's just the zoning bylaw doesn't prohibit what's happening here.
I need to understand what you guys are saying. You're saying that even if you granted the special permit, and in the special permit, you say that one of the conditions is that this driveway will not use for any commercial use. That really doesn't matter. You cannot even put that on this permit.
Commercial agricultural use.
Yeah, commercial. Right. That even if we put it in, it will not hold. We cannot limit that.
Certainly not after the fact. I mean, it's an allowed use in this district, number one, and number two, under Dover, it's got special protection. So I think our hands are a bit tied here. That's my feeling on it. Again, I'm certainly not professing to have, extensive specialized knowledge about, the Dover Amendment or anything like that. It strikes me that our hands are a little bit tied, and maybe that's what the building inspector was thinking about when he made the decision that he made. But I don't think there's anything that we can do to suggest he made an error. I guess that's where I come down. I mean, there are a lot of factual disputes here as to what's the primary use and what isn't. We're certainly not a fact-finding committee here, so I don't think we're going to be able to decide one way or the other necessarily as to what the facts are, because that's not really our purview, and we aren't going to go out and do a site visit and this and that. So I think our hands are a bit tied, and that's kind of where we were when we started. And I think we've given this a lot of airtime, and we've seen a lot of the commentary that's come in after the fact. And I don't think our position has changed all that much.
No, you're right. I felt similarly to how I did at the beginning, and then I reviewed the 100 and whatever pages of documents. I watched the entire meeting, which was a long meeting, at the Board of Appeals meeting. So, and you're right. I don't have any new ideas or ways to look at this really at this point.
So, but the last documents presented by the litigants is that they are talking about the common driveway more than the use of the property or anything else. They are focusing on that. But at least the last two communications that are on record, they are talking only about the common driveways. They are abandoning any other claim about if it is good, if it is according to the bylaw, the use of the land for agricultural purposes. So they are focusing on that driveway, and they are focusing on the decision of this board about issuing the special permit. That's where they are, and is out of our hands mostly because the court already providing an injunction. So right. We can't even get in the middle of that. Is that correct, Rob? If a court
that's kind of how I see it. Yeah, I mean, I don't disagree with what you're saying.
Stephanie, does anyone see any comments or hands raised?
I don't see any.
I happen to be on an iPad today. The buttons.
What is interesting looking at the map is that these three properties could have each one their own driveway.
And Peter, this is on for the board for discussion. It's not a hearing, so it's up to the chair whether you want to recognize anyone. But I do see a
for a brief,
Yep, I do see a hand raised.
Mm-hmm. Okay, well, let's recognize the person with their hand raised, and we'll just ask that we'll keep this any presentations or talks, within a reasonable amount of time. Please.
So I have just allowed the person to speak if they could identify themselves.
Yes, thank you so much, Mr. Chair and Stephanie. This is Kyla Bennett. I live at 2 Chickadee Lane. The member, I'm sorry, I don't know your name, Mr. Kedem was correct. We are asking the planning board, the Planning and Zoning Board as the people who issued the permit to comment to the Zoning Board of Appeals on the common driveway. The common driveway permit was issued in 2005 prior to Easton's right to farm bylaw. And this is not about right to farm or the Dover Amendment. This is about the common driveway. I own a large portion of that driveway. The Gagliardis own a large portion of that driveway. We have, the permit says very clearly, in fact, the judge said in plain language that the use of the driveway was for residential only. The Wolves submitted an affidavit from one of their commercial suppliers saying the driveway was too narrow for him to turn around. The driveway was not designed for commercial use. The permit was not for commercial use. And that is the violation that we are attempting to get addressed. It's not their driveway. Neither the right to farm bylaw nor the Dover Amendment can trump personal property rights. That would be a taking. So if you're telling me right now that a permit that was issued to me in 2005 for my land, that you can now, 16 years later, unilaterally say, oh no, it's okay, they can use it for commercial property, for commercial purposes, is wrong. And the judge agreed with us. And there is an injunction on the driveway for that very reason. The special permit says residential use. The Wolves came to the zoning board, to the Planning and Zoning Board and said, this is for residential use. There will be no congestion problems. There will be no nuisances. There will be nothing because it's just for 3 residences. That was true from 2005 until 2020. Now they have unilaterally changed the use of my driveway and the Gagliardi's driveway, and they're using it for commercial purposes. You cannot say the right to farm bylaw does not allow someone else to take my property and use it for a use that I don't agree to. So that's why we said that the building inspector was wrong when there wasn't a violation, because to me and to the judge, it's very clear that the special permit for the common driveway talks about residential use only. Residential does not equal commercial. It is not their driveway. Thank you.
Thanks.
We have another hand.
Okay.
Hi, yes, thank you, Mr. Chair. Can you hear me okay?
Yes, sir.
Thank you very much. My name is Peter Durning. I'm an attorney at Burns and Levinson, and I am counsel to the owners of 6 Chickadee Lane, Gregory and Barbie Wolf. I'm also counsel to their daughter, Ashley Wolf. I apologize for making a late filing today, but I did submit to the clerk very late today around 5 o'clock a supplemental letter for your review. And I'd just like to touch on a few points. I don't want to belabor this issue too much. I think the way you are discussing it is generally I'm in agreement with. I would make one clarification. I know there's some discussion of the extent to which this is about the driveway rather than the principal use. But I would note that there was a very recent case called Tracer Lane 2 Realty LLC versus the city of Waltham, 489 Mass 775 from just this year, analyzing case law regarding ancillary structures such as driveways and deeming the use of the driveway to be permissible so long as it is used consistent with a principal use. And what we've established in our materials that we've provided to you is that the farm on the Wolf's property is a principal use, and it is consistent with the zoning bylaw. as Mr. Stetson was saying earlier, agricultural uses are allowed in the residential district. This use was allowed when the special permit was issued. There was a reasonable expectation that an agricultural use could proceed on a nearly 9-acre parcel, and this was contemplated. The description of that is present in the common driveway special permit is that it shall be consistent with residential character, not residential use. And I'll just add, I know, as Mr. Stetson noted, that this board is not here in a capacity and as a fact finder, but I would note that divisions of the town of Easton that have performed fact-finding investigations on this property have found it to be consistent with the town's bylaws, including investigations by the animal control officer, Ms. Kristen Kennedy, Kevin Greiner as the zoning enforcement officer, back in the fall of last year, concluded that this property complied with zoning. And Andrea Langhauser also confirmed that this property complies with zoning. I would direct your attention, if you could, to review the letter that I provided, because there was a troubling incident that happened over the weekend. And that is that there was vandalism that was committed on the Wolf's property. I've provided a photograph in the letter that I've sent to the ZBA clerk. And that is that somebody came onto the property and wrote, "Fuck your farm," on the side of the Wolf's barn. Now, I don't think that that is necessarily a measure that you need to take into consideration as you decide whether or not to make a comment. But I do want to draw attention to a lot of the vitriol and invective that has been used to describe activity on the Wolf's property that is consistent with the bylaw, that is a permissible use in the residential district. And I think there's a big effort to describe that activity in very sensationalized and very negative terms. And to the extent that is resulting in animosity rising to the level of somebody coming onto the Wolf property to deface their barn with vulgarities, we are in a sad state at that point. And I think there's positive.
We did receive that, the email, and I saw that, so I agree it was very unfortunate that would happen.
Thank you. I guess I'll trim my remarks, and thank you for that acknowledgement, Mr. Chair. Yeah, I think that the prior commenter mentioned that she was looking for this board to act. I don't think it's in the rules and regulations of the zoning board to even refer a matter that's before it on a review of an enforcement decision for the ZBA to solicit the comments from the planning and zoning board. So I think this is here under some unusual circumstances. Your comments might be advisory, but it is of a limited purpose in nature. I appreciate the time that you gave me to comment today, and I look forward to the zoning board of appeals proceeding next week. Thank you.
Thank you. All right, that might be enough since we've had one from person from both the parties speak. Unless, what do you, Robert, Hamas, what do you think? Should we just keep the flow open for
whatever your pleasure, Mr. Chair.
Okay. I just hoping that we don't just go through the same things that we've either read or heard or seen in the 2-hour meeting that you might have watched. So I think it's mostly similar information, just about the same. So, well, in that case, if there, are we inclined to just suggest that we, Robert, would we make any recommendation based on your, opinion or not, maybe not recommendation or whatever we want to call it, or comment, or just say that it might not be, there's nothing we can do, so there's no need to comment?
Yeah, that's kind of how I feel. I really don't think there's much that we can do here. I don't necessarily disagree with what Mr. Durning said, and in particular, he mentioned the Tracer Lane case, which is a very recent case, and it was in the solar context of the Dover Amendment, and it did specifically relate to an access point, and that, I guess, is kind of what I was getting at when I was commenting to Amos, which is, regardless of what the special permit said, I'm not sure that there would be anything we could do to restrict the use. And, as a zoning, now, I take no position whatsoever on the private rights of these individuals. And as Ms. Bennett pointed out, the judge has already ruled in their favor with respect to certain aspects of their private property rights. And I think there's adequate protection there. So from our perspective, and it's not a preference of any of ours one way or the other. It's just, I think we feel like we're in a limited capacity to be able to comment any further. And that's kind of where I think it should go.
I think we can say exactly that.
Right.
And I don't know if you can word it like, regardless of who is in his right here, from the point of view that we cannot really render any support for any of the both sides for their case. We are not in a position to render an opinion.
I think maybe perhaps if we could maybe summarize that a little differently based on how Robert has described it, that might be something that would be a guiding comment for the Board of Appeals. I'm not sure.
Sure. How about something like this? Based on our review of the materials, we as the planning board do not feel we're in a position to advise on the propriety of the zoning enforcement officer's decision in this matter. And just leave it at that.
Okay.
Sounds reasonable to me. I mean, right, if I were to change it, I would be a little more a little different. But I like what you had to say. So if would you like to vote, or shall we just agree?
I'm open to suggestions, Peter, if you have another way of work.
I think you probably just summarized the way I feel better, so we'll stick with that.
Okay. I'll make a motion to provide that comment to the ZBA.
Kevin, second.
Okay. All those in favor? Kevin?
Aye.
Stetson?
Aye.
DeShane? Yes. So that will be our comments. Suzanne, is that, did you catch most of that?
Yes.
Mm-hmm. Okay. That concludes that agenda item for tonight. Thanks everyone for attending for that item. We have a couple more items on the agenda, but nothing more clerical nature, I think. So we have the 2023 Planning Board meeting schedule. Did either of you two have all right, everyone here? Since we all have
Mr. Chair, should we wait for having more members in order to review that?
Yeah, I'll just say that.
Actually, send that planning and have the members respond via email.
Yeah, I think it's better if we were just to respond with any times that we really can't make it. And that might just help, Greg and Stephanie and Suzanne plan the schedule if there are any days where it's obvious that multiple members can't attend, so.
Yeah,
Okay.
I'd like to commend Suzanne. It's always tricky trying to schedule these, and especially around the few months before annual town meeting when we have any zoning amendments that will require that either Greg or I or both of us attend select board meetings. And she's done a great job of making sure that our meetings are on opposite nights of the select board. And also, I think there's just one Tuesday meeting due to a holiday.
Hey, yes, thank you, Suzanne.
So Stephanie, if you publish that, we can just respond to that, right?
Yes, we will do that.
That's the meeting minutes. I took a quick look at them and they were okay with me.
Good to
And these are
me.
from the last meeting, right? Just the one set.
Yeah.
Motion to approve the meeting minutes, Stetson?
Kadam second.
Okay, all in favor, Stetson?
Aye.
Okay.
Aye.
DeShane, aye. Okay, the meeting minutes from the last meeting are approved. The chair report, well, I'm not the chair, so we'll skip that item. Planning director updates. Stephanie, do you have any quick updates that
I have no updates
worthwhile?
tonight.
Just to share with only the three of us? Okay.
Motion to adjourn.
Stetson, second.
Okay. All in favor, DeShane, aye. Robert,
Aye.
Amas.
Aye.
Okay, meeting is adjourned.
Have a great night, all.
Everybody.
See you on the 21st. Thank you. Goodbye.
Thank you.